James Meredith tried again to register at the University of Mississippi, this time at its Jackson office, and this time accompanied by John Doerr of the Justice Department and U.S. Marshal James McShane.
Funny thing happened there when we came down that hall that you saw the police coming down this narrow hallway, and I thought that we were going to go through a door at the end of the hall, but as we got, I was first, and then Meredith followed me, and then McShane, and when we got to the end of the hall, the door to which I thought we were going to enter was closed, and we were kind of moved sideways, and a door on the side of the hall opened, and there stood the Honorable Ross Barnett, and the television cameras came down over my shoulder, as I remember it, and before Barnett spoke, at length he looked at me, and then he looked at Meredith, and then he looked at McShane, and he said, "Which one of you is James Meredith?"
Thousands of black people felt the victory and saw James Meredith as an example to follow, a symbol, like the Little Rock Nine, of their own power to move the nation.
Well, obviously he was a courageous man. He had lots of nerve, and he was stubborn, persistent. He knew his own mind, and nobody was going to tell him what he should do or what he should not do. The segregation of blacks throughout the South and many places in the country would not have been solved with military. The strategy was focused on voting, and if ever we've seen a situation where the strategy is judged by the results, just look at what happened last week or on Tuesday. I mean, this is... Nobody in the world can believe that we did it. There hasn't been a country in the history of the world that has ever been able to as effectively solve a race or religious problem like this country has solved the race problem.
Referred to as the Gary Cooper of the Kennedy Civil Rights team. I know you're humble about all this stuff, but
you know newspaper people, when they get stuck, they make it up.
Well, here's one of those articles. As bottles, bricks, and stones began to crash around him, he urged the crowd to disperse, reminding them that Medgar Evers wouldn't want them to resort to violence. He asked for help in moving people along, and surprisingly, many listened and complied. I believe that had John Doerr not done what he did, many people would have been killed, said Mr. Henderson. There would have been a riot of epic proportions. Goes on. It is impossible to imagine what direction the civil rights movement would have turned that day without Doerr. A man trained for a courtroom, not to calm an angry crowd. That wasn't his job. He was only there because he was a friend of Evers and wanted to pay his respect. Doerr told Charles Portis of the Los Angeles Times that he took his life in his own hands because, quote, it seemed the only thing to do. Portis went on in his article, said, quote, the Justice Department's John Doerr, a 6'2", 41-year-old unflappable Irishman from Wisconsin, is becoming the Marshall Dillon of the troubled South.
And all I can say is, what are you going to do when what am I going to do when I hear this? It just gets bigger and bigger and bigger. Tell you about the students really were heroes. That Bob Moses, Diane Nash, Chuck McDew, John Lewis, they were really put themselves in really danger. And what Bob always says is that the Civil Rights Division of the Department of Justice gave them crawling space in Mississippi in 1961 through 1964. Just gave them crawling space. They had just a little room to move around. And they kept at it, and they kept at this voting, and urging people to go down to register. By 63, conducting mock elections because for governor and for the various federal officials that were up for office.
Monday, June 22nd, 1964, you get a call at your home in Chevy Chase, Maryland. On the line was Mary King, a staff worker in the Atlanta office of the Student Nonviolent Coordinating Committee. King told Dorr alarming news. On the first day of the Freedom Summer, 3 civil rights workers were missing in East Central Mississippi. King explained that Mickey Schwerner, Andrew Goodman, and James Cheney had set out from Meridian on Sunday morning in a blue station wagon to investigate a church bombing in rural Neshoba County, a known high-risk area. When the 3 failed to return in the afternoon as scheduled, movement workers called local hospitals, jails, and law enforcement offices. The calls yield no word on the whereabouts of the civil rights worker. Could Dorr help? King asked. What was your response when you got that call?
Well, we called the Bureau right away and asked them to conduct an investigation. There was no hesitancy about initiating an investigation, and it was that investigation that really changed the attitude and the effectiveness of the FBI. Before that, the FBI was not a very effective law enforcement agency in the South on civil rights matters. But after that tragedy occurred, President Johnson sent Allen Dulles down to Mississippi to make an investigation, and he came back, and among the things he recommended was that Mr. Hoover beef up the FBI capability in Mississippi, and Mr. Hoover did that.
Portions of your closing statement. I wonder if you would read those last 2 paragraphs, because at least for those who have been Jackson fans, you'll see the connection.
This is an important case. It's important to the government. It's important to the defendants, but most important, it's important to the state of Mississippi. What I say here, what the others lawyers say here today, what the court says about the law will be soon forgotten. But what you 12 people do here today will long be remembered. Then I went on to say, the defendants will stand before you on this record in the case, and they will beg of you of indulgence. In effect, they will say, as Gloucester said as he stood over the body of his slain king, say I slew him not. The king replied, then say they were not slain, but they are dead. If you find that these men are not guilty of this conspiracy, it would be as true to say that there was no nighttime release from jail by Cecil Price. There were no white knights. There were no young men dead. There was no murder. If you find that these men are not guilty, you will declare the law of Neshoba County to be the law of the state of Mississippi.
The proudest part of my career would be, how would you fill in that blank?
Proudest part was working in the Civil Rights Division of the Department of Justice, enforcing federal law with respect to free opportunity for all citizens to vote, free of discrimination.
Conclusion that Professor Neeson used when they honored you. And he concludes, I just think that you deserve a Nobel Peace Prize, John Dorr. John Dorr, a true American hero. Thank you for coming tonight.
Thank you. Thank you.
He's an icon. And we're here to commemorate the Voting Rights Act of 1965, which John Doerr felt so strongly about. And just let me read one paragraph from the source of all sources about the Voting Rights Act of 1965, Wikipedia. It doesn't get any better than that, does it? The Voting Rights Act of 1965 is a landmark piece of federal legislation in the United States that prohibits racial discrimination in voting. It was signed into law by President Lyndon B. Johnson during the height of the American Civil Rights Movement on August 6, 1965, and Congress later amended the act 5 times to expand its protections.
The most important event from my perspective was being able to take 15 students through Mississippi, through Alabama, Tennessee, Georgia, on a traveling seminar reflecting on the legacies of the Civil Rights Act, and meeting with people who were at Selma, meeting with people who were there, who skipped school after the Birmingham bombings and so on. It was deeply moving for the students and deeply important to me as a professor. But Greg has asked me to reflect on these last 2 years on our campus in light of this panel's theme on the Voting Rights Act, what we learned and what is yet to come. And I'd like to touch on 2 themes during my time. The first theme is the effects of the Holder decision and the recent spate in particular that emerged subsequently. Secondly, I'd like to provide some context for thinking about what Congress might do in response. And perhaps you'll not be surprised to find that I'm not so sanguine. Both themes reflect discussions from the ongoing attention we've given these issues at Allegheny College. So I'll start with the proposition that has guided our reflections on campus. Our programming has been premised upon the idea of the desirability of maximizing democratic participation, not just voter participation in elections, but certainly including voter participation in elections. When we planned the 2 years, the court had yet to decide Shelby County versus Holder. When that decision finally came down, there were some who saw our work as having lost its consequence. But as you know, many of the states that had fallen under the pre-clearance requirements of the Voting Rights Act took immediate action within hours of the court's decision, putting into place proposals to restrict ballot access. Our work over the past 2 years, then, has taken on an immediacy and an importance in light of efforts to limit early voting, same-day registration, and to impose what may often be burdensome voter identification requirements. More than 40 states have considered new voter photo identification laws in recent years, with many adopting laws requiring voters to show a non-expired state-issued photo identification before they're allowed to vote. While reducing fraud in elections is an important goal, don't deny that, we must consider at least 2 things if we're to fashion a response that's appropriate. First, we have to consider what type of voter fraud is actually occurring. And second, we have to consider the potential negative consequences for participation as a result of adopting restrictive measures. As you may know, scholarly inquiries and studies cited in court documents indicate that there's very little evidence of in-person voter fraud of the kind that ID laws are designed to address. One set of scholars states the issue rather plainly in their work. This is Alquist, Meyer, and Jackman in a piece last year. Quote, virtually every scholar who has studied voter impersonation fraud has concluded that it is vanishingly rare, and certainly nowhere near the numbers necessary to have an effect on any election. And there's a string citation. They continue, quote, one reason voter impersonation fraud does not occur more often is that it's a crime that makes little sense because the benefits are nearly non-existent while the costs can be enormous. The likelihood that a handful of fraudulent votes would change a result is nearly zero, and any organized effort to cast a significant number would increase the risk of detection and almost certainly require the cooperation of election officials. The penalties for committing voter impersonation fraud are so vastly disproportionate to any plausible benefit that it is a wholly irrational act, close quote. And thus, in-person voter fraud of the kind that voter ID laws are designed to limit is exceedingly rare, if not non-existent. The upshot of much of the scholarly literature is that yes, voter fraud does occur, but is only an issue with respect to absentee voting, not in-person voting. And absentee voting is simply not something that the voter ID laws are designed to address. If there is scholarly evidence and democratically defensible arguments that voter ID laws of the type that's been passed in 22 states since 2010 do indeed address fraud in absentee voting, I've not seen them. Moreover, it would strike me as rather hard to make the case that implementing barriers to voting in the absence of compelling evidence of in-person voter fraud is consistent with democratic principle. As I said, restrictive voting laws have been passed in 22 states since 2010. Several of our speakers on campus have noted that U.S. history is replete with the abuse of voting laws by both parties. It is most certainly a partisan issue, but perhaps more fundamentally, it's a race issue. Of the 11 states with the highest African American turnout in 2008, 7 of them enacted restrictive voting procedures. Of the 12 states with the highest Latino turnout from 2000 to 2010, 9 of them enacted restrictive voting laws. And in North Dakota, for example, every single type of government ID is allowed, except tribal ID. As evidence of the need for a new voter identification bill in New Mexico, lawmakers claimed in the legislative record that they had found 50,000 cases of undocumented immigrants voting. When their claims were challenged and evidence demanded, it was revealed that there were actually 2 cases, not 2,000, 2 cases. And Texas, for example, is currently in federal court as a consequence of a Justice Department investigation into allegations of racially discriminatory voting procedures. That investigation found that, quote, according to the state's own data, a Hispanic registered voter is at least 46.5% and potentially 120% more likely than a non-Hispanic registered voter to lack the identification necessary to vote under Texas law. That case has an interesting history. Texas Senate Bill 14 was originally enacted in 2011. It's one of the strictest photo identification laws in the country, requiring voters to present photo identification from a very limited list before being allowed to vote. The law allows Texans to vote with a concealed handgun license, but not with an ID from a university or a tribal identification card. The law's strict requirements disproportionately prevent certain groups of voters, including African Americans and Latino citizens, from voting in person. In early 2012, D.C. Circuit Court of Appeals denied preclearance under Section 5 of the Voting Rights Act. D.C. Circuit unanimously found that the law discriminated against minority voters, making the statute inoperable for the 2012 elections. In 2013, though, the court decided Shelby County, and by a 5-4 vote, rendered Section 5 of the Voting Rights Act inoperable. Specifically, what they did was they struck Section 4 coverage formula, the triggering mechanism for Section 5 preclearance. Within hours, Texas announced it would implement SB 14. In response, a legal challenge was brought under Section 2 of the Voting Rights Act, something the court did not touch. They didn't touch Section 3 either, obligating Texas to obtain preclearance for future changes in its voting practices. In October of 2014, federal district court struck SB 14. Texas then appealed to the Fifth Circuit, which held oral arguments last Tuesday. So over the course of our 2 years, our campus programming, we hosted many people who know election law best, who know the relevant data, and who know the political landscape. Among them was Gabe Sanchez, a Associate Professor of Political Science, Executive Director of the Robert Wood Johnson Foundation for Health Policy at the University of New Mexico, and also Research Director for Latino Decisions. Gabe has participated as an expert witness in several voter identification cases, including, most recently, cases in Indiana, Wisconsin, Pennsylvania, and, of course, the case I just mentioned in Texas. He and his colleague draw upon more than 20,000 survey observations from both state and national studies to assess the following hypothesis. Quote, increasing institutional requirements on voting will disproportionately decrease participation among those with lower resources. Regrettably, they find ample evidence to support that hypothesis. Here we see the aggregated numbers of all 20,000 plus respondents that were surveyed. This is Gabe Sanchez and Matt Barreto. These are the best data that we have as social scientists exploring this issue, because they're not simply merging state registration data and census data. Rather, they interviewed in person each of the 20,000 respondents using the state level, the appropriate state level legal requirements to determine if the person, the individual respondent, could demonstrate that he or she would meet the state legal requirement for voting. So essentially they asked, do you have this documentation? Yes, I do. Show me. And that was how they were able to determine if indeed the person was able to participate. The statistically significant difference between white and non-white voters is striking. You see, for those of you who cannot see it, it goes from left to right. The first column is white, the second column is black, Latino is the third, and Asian is the fourth. And you'll see it's a statistically significant difference from white to non-white. And because race and partisan identification are often linked, the statistical significant differences are replicated in the partisan divide as well. And here we have on the far left column Republicans, in the middle column we have independents, and the far right column we have Democrats. A statistically significant distinction between Republicans and Democrats. And the pattern is clear in the case of Texas as well, where in 2014, 11.4% of Latino voters and 8.4% of African American voters lacked the photo ID required under SB 14. And so the results. Well, in all, the results indicate that 7.2% of all eligible voters in Texas lacked the necessary ID to comply with SB 14. 7.2% of all eligible voters, white and black, Latino, Asian. And 26.5% of that number, or roughly 318,000 people, lack the documents to acquire the necessary ID. They cannot even get the ID because they don't have the documentation necessary to acquire it. So what kinds of ID tend to be required? We have driver's license, state photo identification card, passport, of course, military ID card. But in some states, we also allow university IDs, state or federal employee IDs, and concealed handgun licenses. Now, what's interesting about this is that even when registrants have the correct identification documentations, they may still have difficulties. And part of that has to do with what happens when they appear before the election officials. When they do appear to vote in person, the election officials in many states have the authority to determine whether they indeed are the person they claim to be. And the only referent for that determination is that ID of some kind. And the standard many states use to apply is whether that person substantially conforms to that image or that signature. And so if I've grown a beard in the meantime and so forth, I may no longer substantially conform. If I've gained a little weight, I may no longer substantially conform. So the amount of discretion that that local election official has really matters with respect to a person's willing or ability to vote, to cast a ballot. But the amount of discretion that local election officials have shouldn't be too big a problem. This should all kind of wash out unless there's a systematic bias at work. If there is a systematic bias in their judgment, then obviously it could be replicated across a whole range of precincts. So a set of scholars looked at that question. And there's a picture. I couldn't quite figure out how to take a screenshot of my computer screen, so I took my phone and took a picture of my computer screen, so here you have it. So this is White, Nathan, and Fowler, a study that they just did this last fall that got published in February of 2015 in the most prestigious journal in the discipline of political science. In this study, the authors conducted a field experiment. And there are other studies like this. This isn't the only one. There are other studies that look at African American responses as well. But this one focuses specifically on Latinos. In this study, they conduct a field experiment in which they contacted over 7,000 election officials responsible for implementing voter ID laws in their states. They find that the officials provided different information to potential voters of different ethnicities. In particular, emails sent from distinctly Latino aliases were significantly less likely to receive any response from election officials than non-Latino alias emails. And those that did generate a response were more likely to be incorrect or incomplete responses than the non-Latino alias emails. So yes, Chief Justice Roberts was right in one sense. Much has been accomplished, certainly since the passage of the Voting Rights Act. But there is much to be done and much to guard against. Regrettably, Section 4 of the Voting Rights Act provided a powerful mechanism to do just that. Justice Ginsburg, in 2013, called the Voting Rights Act of 1965 the most consequential, efficacious, and amply justified exercise of federal legislative power in our nation's history. She wrote that, though, as the majority gutted the Voting Rights Act in Shelby County versus Holder. So without congressional action on Section 4, the Section 5 pre-clearance procedure of the Voting Rights Act will remain dormant as states pick up the pace of adopting restrictive voting procedures. Many of those restrictive voting procedures will have deleterious effects on minority representation, especially at the critically important lowest levels, like school boards, city councils, and so on. Other panelists will likely discuss the decision, its historical context, and effects in greater detail, but there's no doubt that this is a constitutional question of singular importance. But that doesn't mean that Congress will take action. Though there's been some recent movement on nominations like Attorney General Lynch and some legislation, a rewrite of Section 4 is historically linked and, I think, institutionally hobbled. So let me now turn to the likelihood or the possibility of a congressional response. This is a graph that's generated from voteview.com, which is a Poole-Rosenthal set of data. Keith Poole and Harold Rosenthal are political scientists who've really done a great service to the discipline by framing basically all the ideological positions of every person who's ever held public office in the federal government, elected office, from 1789 through today. And so it's a huge data set that's very useful for our purposes. And what we see from looking at these data is that the contemporary Congress is the most politically polarized Congress since Reconstruction. And it appears largely incapable of dealing with major legislative dilemmas. But as you can see, the current level of political polarization could be interpreted just as a return to normal. And the depolarized post-World War II era might actually be the aberrant condition. So take heart. But there's an important story, I think, in these data, too. And it's a story that reveals the difficulties that Congress faces in responding to the court's decision in Shelby County. John Aldrich, was Allegheny class of 1969. He's the Pfizer Pratt Professor of Political Science at Duke University and the president of the American Political Science Association, came to campus last week, or 2 weeks ago, to share some perspectives on the historical foundations of the contemporary era and to think with us about what it would take to overcome that most recent decision. And he began with a reflection on the populist and progressive era, when two important shifts occurred. One was the creation, of course, of the Jim Crow South. Amounted to something very close to an authoritarian one-party state within an otherwise democratic system. The other was the reform efforts, specifically the secret ballot and the institution of primary elections that undermined parties and gave rise to candidate-centered rather than party-centered campaigns. In the post-war era, full-bodied, candidate-centered campaigns emerged with television and the post-Watergate campaign finance changes. The significant incumbency effect that took hold during this era combined with the salience of race and with civil rights to separate the northern and southern wings of the Democratic Party. That, plus the divisions within the Republican Party between Rockefeller Republicans and Goldwater Republicans, which, though comparatively smaller, was real, added up to an unusually depolarized political context, weakened the function, the content, the reputation of parties, and further accelerated this trend toward candidate-centered elections. That context gave us the Civil Rights Act of 1964 and the Voting Rights Act of 65, and those two measures essentially ended the legal structure of Jim Crow. But it took many years to realize that consequence. During the contemporary era, we've seen a rebalancing of the party system and the rise of the Republican Party in the South. That sorting and rebalancing has contributed to the repolarization we observe today. When the campaign financing structure put in place after Watergate fell away, we saw an explosion in the ability of candidates to acquire money based upon their issue positions, their ideological purity, rather than their political experience. We have evidence in political science that campaign funders tend to value ideological reputation more than ever before and value winning office less than ever before. A direct result of that is that candidates, incumbents usually, need not attend to the accommodation and compromise that winning frequently entails. Thus, we see well-funded but less experienced and more ideological challengers emerge. A consequence is that Republicans, in particular Republicans, must look to their right for both potential challengers and financing. That pins them in a position they otherwise would not be in, perhaps, pinning them more sharply to the right than ever before. But it's not just campaign finance that explains the sorting and rebalancing of the contemporary era. In the 1950s, a liberal civil rights agenda led by Northern Democrats began to split the Democratic Party. That division, heightened by the cross-cutting issue of race induced by the successes of the civil rights movement and a television broadcast coverage of the abuses of African Americans, deepened that division into hard, incompatible positions. Though Democrats controlled Congress, the way power was distributed in the chambers by seniority gave Southern Democratic committee chairs disproportionate weight in thwarting Northern Democrats' efforts. The actions of the majority party in passing civil rights and voting rights legislation, coupled with the Republican Southern strategy to break up the New Deal coalition in the South, effectively sorted party elites so that liberal and Democrat became synonymous, as did conservative and Republican. After Jim Crow and after Fannie Lou Hamer changed Democratic Party politics, newly enfranchised blacks in the South began voting Democratic. So the remaining Democratic representatives in the South had to begin to appeal to African Americans in order to get reelected. As a result, they became more ideologically aligned with their Northeastern colleagues. And in response, white Southern Democrats started voting with the GOP, or third parties like Dixiecrats, thereby electing many conservative Republicans to Congress. Thus, the Democratic Party has become more cohesive in its voting. They vote together more than ever before. Conservative coalition votes, in which a majority of Southern Democrats vote with the majority of Republicans, has become much less common. And the GOP in Congress has become more conservative. So here you see the party means on liberal conservative dimension. So the higher the number, the more positive the value. It goes from -1 to +1. The higher the value, the more conservative the party median. And you can see here that the party median for Democrats is roughly about, looks like 0.4. The party median for Republicans is approaching 0.7. As the GOP in Congress has become more conservative, it has also become more Southern. In fact, in 1994, when the Republicans took the House for the first time in 50 years, their new leadership that year was almost exclusively Southern Republicans, the first time that's happened in history. So in sum, we see more intra-party homogeneity of ideological preference, that is, within-party homogeneity of ideological perspectives. But at the same time, we see more inter-party, between-party heterogeneity, polarization. So the Democrats look more and more like each other, and Republicans look more and more like each other, and they look more and more different as clusters. So the parties are more cohesive internally as they diverge ideologically from each other. Once sorted into these camps, the differences have hardened into true polarization and are magnified in light of this candidate-centered campaigning context and buttressed by redistricting. My former representative, I used to live in Georgia, my former representative demonstrates how powerful these forces are. Last fall, John Barrow, you may know the name, Democrat from Georgia, was the lone specimen of the Southern white Democrat in the House. He was one of the only moderate Democrats to have retained his seat over the prior 2 election cycles. Republican redistricting in Georgia made him vulnerable in 2012, and he lost in the 2014 midterms. So now we see 0 white Democrats from the Deep South, and unless Democrats can win state legislatures and governorships, they won't return. One scholar's projection based upon census data was that the earliest point we could expect a return of a white Democrat in the House was 2030. So what does this history mean for legislation in the contemporary era, and in particular for a possible renewal of Section 4? Many studies have shown that Republicans appear to be less willing to compromise than their Democratic colleagues. There's lots of evidence to support this, including these Poole-Rosenthal data. In fact, since about 1976, the GOP party median has increased. That is, it's become more conservative every election year, while the Democrats have remained largely flat. The Democrats tend to cluster closer to the midpoint of zero than do the Republicans. And a recent study by political scientist Adam Bonica shows that campaign funding follows the same pattern. Using ideology measures of those who contribute to candidates, Bonica finds that newly elected Republicans, as the freshmen coming in, attract more extreme money than do continuing members year after year, all other things being equal. The Republicans then appear to have a continuous pull to the right, perhaps to ward off Tea Party challengers, but certainly in a search for money. So what's the lesson? Clearly, political polarization matters. In a Congress with little ideological teeth, such as what we had in the 1950s and 1960s, it may attract those with little interest in partisanship or ideological outcomes. But in a highly charged partisan and ideological context such as we find ourselves in now, it may very well attract those who find those circumstances congenial. In the earlier era, members emerged from electioneering machines, whereas now they tend to emerge from the world of policy advocacy and find little value in compromising or accommodating perspectives that they consider anathema. And with recent changes in rules, have fewer opportunities for accommodation, even if they were so inclined to accommodate. Survey data from my Center for Political Participation at Allegheny College buttress the intractability we observe among members of Congress. Among other interesting results, our study revealed that 49% of voters and 82% of Republican respondents would prefer their representatives to not compromise on certain measures. So there is a disinclination to accommodate among many in Congress that also has an electoral and fundraising connection. And in the Senate, all it takes is one to thwart movement. So we have to consider the institutional structures that must be overcome in Congress in order to pass major legislation, that is, the veto and filibuster-proof supermajority requirements.
Hey, Brian,
Yeah.
I know you got to get back, so I don't want to have you be late for your classes.
Okay, thank you. Yeah, all right, yeah, thank you. That's important. I have to give a final exam in con law in about 2 hours, so I have just a brief bit more. So what polarization does is it increases the distance the median member of a party's caucus has to move ideologically to overcome the supermajoritarian requirements. The 290th member of the House, the 60th member of the Senate, the 67th member of the Senate for a veto override. But a willingness to compromise or to accommodate those with whom one disagrees is a necessary condition for positive governmental action, like healthcare reform or to build a post office. Obviously, if there's a right that is recognized by governmental authority, then there is a corresponding duty to secure that right by that authority. If we assume that there's a right to vote, then government bears the obligation to ensure access. But coordinated action is required to overcome the supermajoritarian context that attends policy change in Section 4 at the federal level. Accommodation, compromise, and bargaining are therefore implicated. But one cannot bargain from a predisposition to intractability, a predisposition that has its roots in candidate-centered ideological fundraising requirements for contemporary office. But perhaps that difficulty poses some solutions. We can ask what role shareholders might play in shaping political expenditures by corporations, the source of much of the money in politics. If firms needn't reveal their identity in support of political expenditures, is there a realistic way to balance their influence? Might we, for example, be able to disconnect money from its source? Perhaps money isn't the problem, as much as knowing who gave it to you, creating a conflict of interest. Perhaps we could anonymize political expenditures such that it would both pass constitutional muster, that is, speech, and still allow funders to support policies and candidates they favor. Strategies being employed in New York City or Seattle recently might give us some clues as to how we might begin to limit the role of money in politics. What rule changes might grease the wheels of accommodation the way earmarks might have in previous Congresses? But these would be significant shifts and would themselves, clearly, have to overcome the inertia that besets the contemporary Congress. One might be inclined to think that only the court could clean it up. But that's not likely to happen, of course. So, thanks for the invitation to be here today. I've provided my contact information here if you want to continue or if you have thoughts about the presentation. But as I said, I regrettably, I have to get away to give an exam to my students, and so I'll be grading the rest of the evening while you celebrate. So thank you again for your attention. I appreciate the opportunity.